Imagine you file a lawsuit for a very specific, very urgent reason. Now, imagine that case takes so long to get resolved that the original reason, well, it just completely disappears. That is exactly what happened in a legal battle that stretched over 3 decades, and it forced the Supreme Court to ask a really fundamental question. Which facts matter more, the ones you started with, or the new ones that pop up along the way?
So let's just trace the journey here, because it's a wild one. It all kicks off in 1994. 7 years later, 2001, we get our first verdict. Then you got to fast forward all the way to 2023 when a new piece of evidence completely changes the game. And it's not until 2026 that the Supreme Court finally makes its move. That's a 32-year saga, all over a single room.
All right, so how did this whole thing even start? Let's rewind all the way back to the beginning, to what seemed like a simple and pretty urgent family need. Okay, so here's the setup. Back in 1994, the Martins family, they're the landlords, they file a suit to evict their tenants, the Zuzarte family, from a place called room number 59 in Mumbai. And the reason was pretty simple and, heartfelt. They needed that room for the privacy of the family matriarch. She was an 87-year-old widow who had 6 daughters constantly visiting her. But the Zuzarte family, the tenants, they pushed back. They denied that this need was genuine, and they decided to fight the eviction. Now, the entire case, and I mean the whole thing, hinged on this legal concept called bonafide need. See, it's not enough for a landlord to just want their property back. They have to prove to the court that their need is genuine, that it's honest, and that it's pretty pressing. This was the absolute foundation of the Martins family's entire argument. What started out as this, straightforward claim, well, it quickly spiraled into a total legal marathon. It became this decades-long battle that took these families from the local trial court to the appellate court and then all the way up to the high court. At first, it really seemed like things were going the Martins' way. In 2001, after 7 long years, the trial court looked at all the evidence and sided with them. It found that, yes, their need for the room was bona fide. The eviction was approved. But this is where the story takes its first huge twist. The Zuzartes, of course, appealed to a higher court. And in the years it took for that appeal to finally be heard, the Martins' mother passed away. The appellate court saw this as a critical, subsequent event that completely changed the facts on the ground. The original reason for the eviction? Poof, it was just gone. And just like that, the decision was reversed. The eviction was off. So the Martins family, they don't give up. They take the case to the high court. But then, get this, another twist emerges. In 2023, we're now nearly 30 years into this thing. The tenants submit brand new evidence, an affidavit saying the Martins family had another room number 63, that they weren't even using. The high court took this new evidence, noted that the Martins family didn't formally fight back against it, and confirmed the reversal. The Martins family had lost again. So you can imagine, by the time this case finally lands at the Supreme Court, it is a mess. It's tangled up in decades of litigation with facts that have completely morphed over time. And this forced the court to grapple with a really fundamental question. What in the world do you do when new facts emerge so late in the game? This is the core dilemma the Supreme Court had to unravel, right? In a lawsuit this long, what should a judge focus on? The landlord's genuine need all the way back in 1994? Or the fact that the mother had since passed away and, oh, by the way, another room might have become available by 2023. It's a fascinating legal puzzle. Now, to solve this, the court couldn't just, look at this one case in a vacuum. They had to turn to precedent, to legal principles. Basically, the guiding rulebook for situations exactly like this one. The Supreme Court looked back at some established case law, which laid out a really clear rule. A case should be judged on the facts as they existed on the day the lawsuit was filed. For this case, that meant hitting the rewind button all the way back to 1994. And the why behind this rule is so powerful. The court basically says that a person who files a lawsuit, well, they should not be penalized for the slowness of the legal system. Think about that. It's a powerful declaration that justice delayed shouldn't automatically mean justice is denied. Okay, so here's the crucial point. The default setting is to look at the original facts, but there's an exception. A court can consider new events, but the bar for that, it is incredibly high. The new information has to be so major that it, quote, completely eclipses the landlord's original need, basically making it totally irrelevant. And it's not just a gut feeling. There's actually a formal 3-part test for this. For court to even consider a new event, it has to check 3 boxes. 1, it has to be raised promptly. 2, it has to be submitted through the proper legal channels. And 3, this is the big one, it has to be significant enough to actually have a material bearing on the final decision.
All right, so with all these rules in mind, how did the Supreme Court apply them to the Martins versus Zuzarte case? Well, the final judgment is kind of surprising, and it sends everyone right back to where they started. The Supreme Court found a critical flaw in the High Court's process. It had dismissed the Martins' claim almost entirely based on that 2023 affidavit about the second room. The problem was, it failed to properly weigh that new piece of information against all the original evidence that was presented way back in 2001, the evidence that had initially won them the case. So the final verdict wasn't a victory for either family. In a move that is just stunning, the Supreme Court wipes the slate clean. It set aside all the previous judgments and sent the case back to the very beginning. After 32 years, this entire legal battle was getting a complete do-over. And the orders were super specific, totally absolute. Every single decision since 2001, gone, wiped from the record. The case was sent back to the very first court in Mumbai. Both families were allowed to change their claims and submit brand new evidence. And this time, there was a strict deadline. The court had just 1 year to finally decide the case. You know, this whole saga, from an 87-year-old's need for privacy in 1994 all the way to a court-ordered reset in 2026, it really shines a light on the profound challenges of a slow-moving legal system. And it leaves us with a really heavy question to consider. After decades of fighting, when the original people and the original reasons are long gone, what does winning even look like?